Sheffield, Massachusetts, 1780. Winter came early that year, snow piling against the windows of the Ashley mansion while fire roared in the kitchen hearth. Elizabeth Freeman, known as Mum Bet to everyone who owned her, stood at that hearth preparing the midday meal. She was 38 years old. She'd been enslaved since childhood, and she was about to make a decision that would destroy slavery in Massachusetts. The Ashley household operated on a contradiction so blatant it was almost artistic in its hypocrisy. Colonel John Ashley was one of Massachusetts's most prominent lawyers, a man of education and refinement who'd helped draft the Sheffield Declaration 7 years earlier. That document, penned in 1773, proclaimed that all men are born free and equal, and that mankind possessed the same natural freedom as other men. Ashley kept a copy of that declaration in his study, framed, displayed like a trophy of progressive thought. He also kept 6 human beings as property. Mum Bet could neither read nor write, but she'd spent 38 years listening to Ashley and his lawyer friends debate philosophy in the parlor while she served them tea, listening to them discuss the Revolution, the new Massachusetts Constitution, the rights of man, listening to words like liberty and equality and natural freedom spoken by men who returned home to be served by people they owned. She'd learned to be invisible, the way enslaved people learned to be invisible, present but not present, seen but not noticed. And in that invisibility, she'd absorbed everything, every legal argument, every philosophical principle, every word they'd used to justify their revolution against British tyranny. She was collecting ammunition. Hannah Ashley was Colonel Ashley's wife, and where her husband practiced sophisticated hypocrisy, Hannah practiced straightforward cruelty. She was a woman who understood that ownership meant power, and power meant violence. When the food wasn't prepared correctly, she used her hands. When the cleaning wasn't sufficient, she used whatever implement was nearby. When she was in a mood, and she was often in a mood, she used whatever would leave the deepest mark. That winter morning, it was her younger sister Lizzie who made the mistake. Something about how the bread had been baked, some trivial detail that mattered only to someone looking for a reason to inflict pain. Hannah's voice rose in the kitchen, sharp and cruel. Lizzie tried to apologize, tried to explain, but explanation was never the point. Hannah grabbed the fireplace poker from the hearth. The poker had been heating for the better part of an hour, its tip glowing orange-red from proximity to flames. Hannah pulled it from the fire and swung it at Lizzie's head with the kind of casual violence that came from knowing there would be no consequences. Mum Bet threw her arm up without thinking. The poker connected with her forearm instead of her sister's skull. The sound was terrible, flesh sizzling, the smell immediate and sickening. The pain was worse. A burn doesn't hurt like a cut or a blow. It hurts in layers, each one deeper than the last, the nerve endings screaming different messages as different tissues cook. Mum Bet made no sound. Hannah Ashley stared at her for a moment, perhaps surprised by the intervention, perhaps merely recalculating her target. Then she returned the poker to the fire and left the kitchen without another word. Punishment delivered, lesson taught, nothing more to discuss. Lizzie rushed to examine the wound. It was bad. The poker had seared through skin and into the meat of Mum Bet's forearm, leaving a burn several inches long, maybe an inch wide, the edges charred black, the center weeping clear fluid that would soon turn to pus if infection set in. "We need to treat this," Lizzie said, her hands shaking. "Bandage it properly, keep it clean." "No," Mum Bet said. "It'll scar terrible if we don't—" "Good." Lizzie stared at her sister, not understanding. Mum Bet wrapped the wound loosely in clean cloth, enough to keep dirt out but not enough to promote proper healing. She'd spent 38 years watching white people debate the nature of freedom while practicing the mechanics of ownership. She'd listened to Colonel Ashley talk about equality while counting his human property as assets in his ledger. She'd learned that in America, words meant nothing unless you could prove they meant something. And she'd just acquired proof. Over the following weeks, Mum Bet tended that burn with deliberate negligence. She cleaned it just enough to prevent life-threatening infection, but not enough to encourage proper healing. She let it scar raised and ugly, the tissue forming thick ridges that would never smooth out, never fade to something unnoticeable. Every time someone asked about it, she told them exactly what had happened. Hannah Ashley had swung a heated poker at Lizzie's head. Mum Bet had blocked it. This was the result. She told the story calmly, without embellishment, letting the scar speak for itself. The other enslaved people in the household understood immediately what she was doing. They'd seen people preserve evidence before, keep torn clothing from a beating, save bloodied rags, hide broken teeth. Evidence of what was done to you in a system that claimed you had no right to complain about what was done to you. But they'd never seen anyone weaponize a wound quite like this. Colonel Ashley noticed the scar during dinner one evening when Mum Bet was serving. He asked what had happened. She told him. He nodded, said something about his wife's temper, and returned to his meal. The hypocrisy didn't even register with him. In his study, he had a document declaring all men equal. At his table, he had a woman bearing a burn scar from his wife's violence, and the two realities coexisted without apparent contradiction. That's when Mum Bet knew she had him. Massachusetts had ratified a new constitution in 1780, just months before the poker incident. That constitution, which Colonel Ashley had helped promote, contained language about inherent freedom and equality. It was aspirational language, philosophical language, the kind of high-minded principle that educated men enjoyed debating over port and cigars. But it was also law. Mum Bet couldn't read the document herself, but she'd listened to Ashley discuss it. She'd heard him explain the legal principles to visitors. She'd absorbed the arguments, the precedents, the philosophy, and she'd reached a conclusion that terrified every enslaver in Massachusetts, even though they didn't know it yet. If the Constitution said all men were born free and equal, and if that Constitution was law, then slavery was illegal, not immoral, not unfortunate, not something to be gradually phased out. Illegal. Right now, under current law. She just needed someone to argue it in court. The scar on her arm had stopped hurting by then, the nerve damage creating permanent numbness in a patch of skin that would never feel temperature or texture again. But the scar itself was vivid, raised, discolored, impossible to ignore. Physical evidence of violence committed by the wife of a man who preached equality. Mum Bet looked at that scar every day and thought about the words she'd heard so many times in Colonel Ashley's study. All men are born free and equal. She thought about the Constitution, about laws, about how white men had fought a revolution because they considered themselves enslaved by British taxation and tyranny. If being taxed without representation was slavery, what was being bought and sold as property? She made her decision in the spring of 1781, after months of letting that scar heal wrong on purpose, after months of collecting her thoughts and preparing her argument. She would take the law at its word. She would walk into a courtroom and force Massachusetts to decide either the Constitution meant what it said, or it was just more pretty words from men who thought freedom applied to them, but not to her. The scar was her evidence. The Constitution was her weapon. And Colonel Ashley, the man who owned her and wrote about equality in the same afternoon, was about to discover that words have consequences when the people you own learn to read them back to you. Theodore Sedgwick's office in Sheffield was everything you'd expect from one of Massachusetts's most prominent attorneys. Law books lined the walls floor to ceiling, their spines cracked from use. A large desk dominated the center of the room, covered in papers and writs and legal documents written in the careful hand of a man who understood that words were weapons if you knew how to wield them properly. Sedgwick was 35 years old in the spring of 1781, ambitious and talented, with political aspirations that extended well beyond representing property disputes and contract disagreements in western Massachusetts. He'd served in the Continental Congress. He had connections to the most powerful families in the state. He was being groomed for greater things. State legislature, maybe eventually Congress again, perhaps even higher office if he played his cards correctly. Taking on a slave's freedom suit wasn't playing his cards correctly. It was professional suicide. Massachusetts in 1781 was technically in flux on the slavery question. The new Constitution, ratified the previous year, contained language about equality and natural rights that made slavery legally questionable. But questionable wasn't the same as prohibited. Dozens of prominent families, including most of Sedgwick's clients, held enslaved people as property. The economy of western Massachusetts, while not as dependent on slavery as the South, still relied on it enough that challenging the institution directly meant challenging the people who paid his bills. No sensible lawyer would risk that for a slave woman with no money and no power, which is why Sedgwick was very surprised when Mum Bet walked into his office that spring morning without an appointment, without permission, without showing any sign that she understood the social boundaries she was crossing just by being there. "I need you to sue Colonel Ashley," she said, not asked, standing in front of his desk with her arms crossed. Sedgwick looked up from the brief he was preparing. He knew who she was. Everyone in Sheffield knew everyone else's business, including which families owned which enslaved people. Mum Bet belonged to the Ashleys, had for decades, was known as competent, quiet, not prone to causing trouble. "I don't understand," Sedgwick said carefully, setting down his pen. "Yes, you do," Mum Bet said. "Your Constitution says all men are born free and equal. Colonel Ashley keeps me as property. Those two things contradict. I want you to argue that contradiction in court." Sedgwick stared at her. It took him a moment to process what she was actually asking for. Not to negotiate better treatment, not to arrange a purchase of freedom, but to challenge, in a court of law, whether slavery itself was legal under the Massachusetts Constitution. "That's complicated," he said finally. "No, it isn't. Either the words mean something or they don't." Sedgwick stood up, started to pace. He was a lawyer, which meant his mind automatically jumped to all the reasons why this case was impossible. No precedent for a successful freedom suit in Massachusetts. Every judge in the state came from families that owned slaves. The economic implications of declaring slavery illegal would be staggering. The political backlash would destroy his career before it really started. "Mrs. He paused, realizing he didn't know what to call her. Enslaved people often had no legal surnames. "Freeman," she said. "That's the name I'm taking when you win this case. Elizabeth Freeman. You can call me that now or after the trial. Doesn't matter to me." The audacity of it was stunning. She'd walked into his office already certain of victory, already chosen a free name, already decided that this white lawyer with everything to lose was going to risk it all for her. "I need to explain the legal realities," Sedgwick began. Mum Bet rolled up her right sleeve. The scar was impossible to ignore. Raised, discolored, running several inches across her forearm. It was the kind of scar that came from serious injury, the kind that made you wonder how the person survived it. "Hannah Ashley hit me with a heated fireplace poker," Mum Bet said, her voice steady and factual. "I blocked it to protect my sister. She would have died if that poker hit her head. I let this scar heal wrong on purpose. It's evidence." Sedgwick looked at the scar, at her face, at the scar again. He understood immediately what she'd done. Physical evidence of violence committed by a master, or in this case, a master's wife, against an enslaved person. In a system where enslaved people had no legal standing to complain about their treatment, she'd manufactured proof that couldn't be dismissed or ignored. "Evidence of what?" he asked, though he already knew. "That your words about freedom and equality are lies, unless you defend them when it's inconvenient." That hit harder than it should have. Sedgwick had written plenty of passionate words about liberty during the Revolution, had argued about the rights of man, about freedom from tyranny, about the principles that justified rebellion against British rule. Like most of his peers, he'd managed to make those arguments while not really thinking about the people his clients owned, the contradiction between revolutionary rhetoric and continued slavery somehow not registering as the hypocrisy it obviously was. Having it pointed out by an illiterate enslaved woman in his own office was uncomfortable in ways he couldn't quite articulate. "You understand this will be dangerous?" he said. "For you, I mean. If we bring this suit and lose, Colonel Ashley could sell you south, send you to a place where conditions are far worse than what you have now. I understand that if I don't bring this suit, I die enslaved. Either way, I'm risking my life. Only one of those risks has a chance of making my daughter free." She had a daughter. Sedgwick hadn't known that. The knowledge changed the calculation somehow, made it more real. This wasn't just abstract principle or legal theory. This was a woman trying to ensure her child didn't inherit bondage. I'll need to think about this, Sedgwick said. The legal questions are complex. No, they aren't, Mumbet interrupted. You're not thinking about legal questions. You're thinking about what your friends will say, what your clients will do, whether this helps or hurts your career. Those aren't legal questions. Those are coward questions. No one had ever called Theodore Sedgwick a coward to his face. He'd served in the Revolution, risked his life for the cause of liberty, fought against British tyranny. And now this woman was standing in his office implying that everything he'd fought for was meaningless unless he was willing to defend it when it cost him something. Give me 1 week, he said finally. I need to research the case law, understand the constitutional arguments. You have 3 days, Mumbet said. After that, I'm going to another lawyer, and another one after that. And I'll keep going until I find someone brave enough to take words seriously. She turned and left before Sedgwick could respond, the door closing behind her with a quiet click that somehow sounded louder than a slam would have. Sedgwick sat back down at his desk and looked at the brief he'd been writing when she arrived. It was about a property dispute, something trivial about fence lines between neighboring farms. He'd been planning to spend the week crafting arguments, filing motions, doing the routine work that kept his practice profitable and his reputation solid. Instead, he spent the next 3 days reading and rereading the Massachusetts Constitution. Article 1 declared that all men are born free and equal and have certain natural, essential, and unalienable rights. The language was clear, unambiguous, explicitly universal. No qualifications, no exceptions, just a blanket statement about human equality that the framers had written while many of them owned other human beings. The hypocrisy was so blatant, it was almost elegant. They'd written equality into law while practicing inequality as policy. And no one had seriously challenged it, because no one wanted to deal with the implications of what those words actually meant if you took them at face value. Mumbet was going to make them deal with it. Sedgwick researched precedents. There weren't many freedom suits in Massachusetts, and the ones that existed had failed or been dismissed on technicalities. He looked for case law in other states, found some successful suits, but nothing that would bind a Massachusetts court, which meant he'd have to argue from first principles, from the Constitution itself, from the idea that words meant what they said, and if the Constitution declared all men equal, then slavery was illegal under current law. No grandfather clause, no gradual abolition, just immediate, uncompromising freedom for every enslaved person in the state. If he won, he'd make history. If he lost, he'd still make history, just as the lawyer who tried and failed to end slavery through a frivolous lawsuit that wasted the court's time and annoyed powerful people. On the 3rd day, Mumbet returned to his office. Well, she said. I'll take the case, Sedgwick said, but I need another enslaved person to join the suit. 1 plaintiff can be dismissed as an individual grievance. 2 makes it harder to ignore. I already talked to Brom, Mumbet said. He's owned by Colonel Ashley, too. He'll join. You already... Sedgwick stopped, realized he should have expected this. She hadn't spent 3 days waiting to see if he'd accept. She'd spent 3 days preparing for when he did. Of course you did. When's the trial? I'll file the suit this week, with the court schedule probably August. That gives us 4 months to prepare. What do you need from me? Your testimony, the scar, and we need to make sure you don't say anything that makes you seem angry or vengeful. Judges don't like uppity slaves. Mumbet gave him a look that could have frozen water in July. I've spent 38 years making white people comfortable. I know how to play the role. Over the following months, Sedgwick prepared the case with an obsessiveness that surprised him. He'd taken on the suit expecting to do competent work, make a good faith effort, and lose in a way that at least established some useful precedent for future attempts. But the more he worked with Mumbet, the more he realized she wasn't preparing to lose. She was preparing to dismantle the entire legal framework of slavery in Massachusetts using nothing but the Constitution's own words and a scar she'd refused to let heal properly. She'd memorized the relevant constitutional passages despite being unable to read. She understood the counter-arguments better than Sedgwick's law clerk did. She knew exactly which points would resonate with a jury of white men and which points would make them defensive. She'd been planning this longer than Sedgwick had been alive. She just hadn't had access to a courtroom until now. News of the suit spread through western Massachusetts like wildfire. People were shocked that Sedgwick had taken it, shocked that Ashley was letting it proceed rather than just selling Mumbet and Brahms south before trial, shocked that a court was actually going to hear arguments about whether slavery itself was legal. The local taverns buzzed with debate. Some thought it was noble, a principled stand about constitutional interpretation. Most thought it was dangerous, an attack on property rights that could destabilize the entire economy. A few thought it was hilarious, a doomed legal stunt that would end with Sedgwick being laughed out of every courtroom in Massachusetts. Sedgwick received anonymous letters warning him to drop the case, received not-so-anonymous visits from clients threatening to take their business elsewhere, received advice from mentors that taking this stand would end his political career before it really began. He kept preparing anyway, partly because he'd given his word, partly because Mumbet had called him a coward and he was determined to prove her wrong, and partly because he'd read the Constitution enough times now that he couldn't unsee the contradiction between its words and Massachusetts's reality. The trial was set for August 21st, 1781, in Great Barrington. Sedgwick filed his motions, prepared his arguments, and tried to feel confident about a case that everyone said he'd lose. The night before trial, Mumbet showed up at his door. "Tomorrow," she said, "when I testify, I'm going to ask the jury a question." "What question?" "If all men are born free and equal, which word doesn't apply to me? All? Men? Born? Free? Or equal?" Sedgwick thought about it. It was good. Simple, direct, forcing the jury to articulate exactly which part of the Constitution they thought excluded her. "That could work," he said. "It'll work," Mumbet corrected, "because there's no good answer. Every word applies, which means I'm free. The jury just has to admit it." She left, leaving Sedgwick standing in his doorway wondering how an illiterate enslaved woman had become better at legal strategy than he was. The courtroom in Great Barrington was packed when they arrived the next morning. Every seat filled, people standing in the back, others gathered outside hoping to hear the proceedings through the open windows. The judge, William Whiting, took his seat. The jury filed in. 12 white men, most of them property owners, several of them slaveholders themselves. Colonel Ashley sat in the front row, confident, relaxed, like a man attending a mildly entertaining theatrical performance. Mumbet sat at the plaintiff's table, her hands folded, her expression calm. The bailiff called the court to order, and Theodore Sedgwick stood up to argue that slavery in Massachusetts was already illegal, had been illegal since the Constitution's ratification, and every enslaved person in the state was free right now under current law, whether the slaveholders wanted to admit it or not. The defense attorney smiled when Sedgwick finished his opening statement. "Interesting theory, Mr. Sedgwick," he said. "Now let me explain why reality disagrees." Colonel Ashley's attorney was named John Canfield, and he looked exactly like what you'd expect from a man defending slavery in 1781 Massachusetts. Expensive coat, confident posture, the expression of someone who'd never lost an argument in his life because he'd never argued from the losing side. He stood before the jury, hands clasped behind his back, and delivered his opening statement with the casual authority of a man explaining basic mathematics to children. "Gentlemen of the jury," Canfield began, "Mr. Sedgwick would have you believe that a single sentence in our Constitution has magically erased an institution that has existed in this colony, this state, for over a century. He would have you believe that thousands of property owners woke up one morning to discover that their legally acquired assets had suddenly become free human beings. He would have you believe that the framers of our Constitution, many of whom owned slaves themselves, intended to immediately abolish slavery without compensation, without transition, without any consideration for the economic chaos such a decision would create." Canfield paused, letting the jury absorb the absurdity he was presenting. Several jurors nodded. They understood the argument. It made sense in the way that maintaining comfortable systems always makes sense to people who benefit from them. "The plaintiff's case rests on a deliberate misreading of aspirational language," Canfield continued. "The Constitution speaks of equality and freedom, yes. But these are philosophical principles, guiding ideals for how we should structure our society going forward. They are not immediate legal mandates that overturn centuries of established practice. He gestured toward Mum Bet and Brom, sitting at the plaintiff's table. These individuals are property, legally acquired by Colonel Ashley through legitimate purchase. They have been well treated, well fed, given shelter and purpose. The plaintiff Bet bears a scar, yes, from an unfortunate domestic incident. But such incidents occur in all households. Are we to say that every accidental injury committed by a property owner against their property constitutes grounds for emancipation? Mum Bet's expression didn't change, but Sedgwick saw her jaw tighten slightly. Accidental injury. That's how Canfield was framing a deliberate assault with a heated poker. The economic implications alone should give you pause, Canfield said, warming to his theme. If you rule for the plaintiffs, you will not simply be freeing two individuals. You will be establishing precedent that frees every enslaved person in Massachusetts. Hundreds of families will lose property they legally purchased. Hundreds of farms and businesses will lose the labor that makes them economically viable. You will be creating chaos from order, poverty from prosperity, all based on a poetic interpretation of language that the framers never intended to have immediate legal force. Canfield walked closer to the jury box, his voice dropping to a confidential tone. I know what Mr. Sedgwick will argue. He'll talk about natural rights and equality and freedom. Beautiful words, important ideas. But gentlemen, we live in the real world, not a philosophy textbook. In the real world, property rights matter. In the real world, economic stability matters. In the real world, we cannot simply overturn an entire social system because of how we choose to interpret a single sentence. He returned to his position, straightened his coat, and delivered his conclusion. The plaintiffs are asking you to rewrite the laws of property, economics, and social order based on aspirational language never intended to have immediate legal effect. I trust you will see the folly in such a request and rule accordingly. Canfield sat down, looking satisfied. It had been a strong argument, Sedgwick had to admit. Hit all the points that would resonate with property-owning jurors who understood perfectly well what they stood to lose if slavery was declared illegal. Judge Whiting nodded. Mr. Sedgwick, you may call your first witness. Sedgwick stood. The plaintiff calls Elizabeth Freeman to the stand. The courtroom went silent as Mum Bet walked to the witness stand. She'd dressed simply but respectably, the kind of clothing a free domestic servant might wear. Her movements were calm, unhurried, as if she'd testified in court 100 times before instead of never. The bailiff administered the oath. Mum Bet placed her hand on the Bible and swore to tell the truth, the whole truth, and nothing but the truth. The irony wasn't lost on anyone present. A slave swearing on a Bible to tell the truth in a legal system that considered her property without standing to give testimony about her own condition. Sedgwick approached the witness stand with notes he'd prepared, questions designed to establish the facts of her enslavement and the circumstances of her injury. Mrs. Freeman, how long have you been enslaved? Since I was born, Mum Bet said. 38 years. And during that time, have you been bought and sold? 3 times. First as a child when my original owner died, then to Colonel Ashley's father, then inherited by Colonel Ashley himself. You've never been free? Never had the opportunity to choose your own life? No, sir. I've been property my entire life. Sedgwick walked her through the basic facts. The daily labor she performed, the lack of compensation, the inability to leave, to refuse work, to have any legal say in her own existence. Then he moved to the incident with the poker. Mrs. Freeman, can you describe what happened on the day you received the scar on your arm? Mum Bet's voice remained steady, factual. Mrs. Ashley was angry at my sister Lizzie about something. She grabbed a fireplace poker that had been heating in the fire. The tip was hot enough that it glowed. She swung it at Lizzie's head. I put my arm up to block it. Why did you block it? Because if it hit Lizzie's head, it would have killed her. And what happened to your arm? The poker burned through the skin and into the flesh. It hurt worse than anything I'd experienced before. Did you receive medical treatment? I cleaned it and wrapped it. That's all. Why didn't you seek better care? Why didn't you treat it properly so the scarring would be minimal? Mum Bet looked directly at the jury when she answered. Because I wanted people to see what was done to me. I wanted evidence that couldn't be denied or ignored. Sedgwick gestured to her arm. May I ask you to show the jury the result of that injury? Mum Bet rolled up her right sleeve. The scar was prominent, raised, impossible to miss. Several jurors leaned forward to see better. One of them flinched visibly. That scar, Sedgwick said, is the result of an act of violence committed by your owner's wife. In a system where you are considered property, you have no legal recourse for such violence, no way to seek justice, no protection under law. Is that correct? That's correct, Mum Bet said. Sedgwick returned to his notes, but Mum Bet wasn't finished. May I ask the jury a question? She said. Judge Whiting looked surprised. Witnesses didn't ask questions during testimony, but he was curious enough to allow it. You may. Mum Bet looked directly at the 12 men in the jury box. Her voice remained calm, but every word landed with precision. The Massachusetts Constitution says all men are born free and equal. Those are the exact words. All men born free, equal. She paused. I'd like someone to explain to me which of those words doesn't apply to me. The courtroom went absolutely silent. Is it all? Mum Bet continued. Does all not mean all? Is it men? Does men not include women? Though I notice the law seems to include women when it's convenient for property claims. Is it born? Because I was certainly born. Or is it free and equal? Because if those words don't mean free and equal, then what do they mean? No one answered. Several jurors shifted uncomfortably. Canfield started to object, then seemed to realize that objecting would only draw more attention to questions he couldn't answer. I can't read, Mum Bet said. Never had the opportunity to learn. But I've listened to educated men talk about that Constitution for a year now. Listened to them explain what it means, what the framers intended, what the words supposedly imply. And every explanation I've heard sounds like people trying to find reasons why clear words don't mean what they obviously say. She looked at Judge Whiting. That's all I wanted to ask. Sedgwick had prepared follow-up questions, but he realized Mum Bet had just done something more effective than anything he'd planned. She'd forced the jury to confront the plain meaning of words they'd been trained to read around. No further questions, Sedgwick said. Canfield stood for cross-examination, looking less confident than he had during opening statements. Mrs. Freeman, he said, the pause before her chosen name deliberate. You claim you've been mistreated, yet you appear healthy, well-fed, clothed. Is Colonel Ashley a cruel master? He's a kind slave owner, Mum Bet said, which is like being a merciful murderer. The kindness doesn't change what you are. Several people in the courtroom gallery gasped. Canfield's expression hardened. You're asking this jury to overturn centuries of law and practice based on your personal desire for freedom. Do you have any conception of the chaos that would result? I have conception of 38 years as property, Mum Bet said. That's chaos enough for me. Canfield tried several more lines of questioning, attempting to shake her testimony, to make her seem angry or unreasonable or uppity. But Mum Bet remained calm, factual, responding to each question with the kind of measured intelligence that made it impossible to dismiss her as an ignorant slave who didn't understand the complexities of law and society. After 20 minutes, Canfield gave up and sat down. Sedgwick called Brom to testify. Brom's testimony was simpler, less dramatic, but it served an important purpose, establishing that this wasn't just about one woman's grievance. Multiple enslaved people were claiming freedom under the same constitutional provision. Then Sedgwick rested his case. Canfield called Colonel Ashley to the stand. Ashley testified that he'd purchased Mum Bet legally, treated her well, provided for her needs. He expressed regret about the incident with the poker, but characterized it as an unfortunate accident, a moment of temper from his wife that didn't reflect their general household practices. Do you believe Mrs. Freeman has been treated unjustly? Canfield asked. I believe she's been treated as well as anyone could expect for someone in her position, Ashley said. She's had shelter, food, purpose. Many free people have less. Do you believe the Constitution intended to immediately free all enslaved people when it was ratified? Of course not. I helped promote that Constitution. I know what the framers intended. The language about equality is aspirational, not operational. It's a goal we work toward, not a mandate that takes effect immediately regardless of circumstances. Sedgwick's cross-examination was brief and devastating. Colonel Ashley, you helped draft the Sheffield Declaration in 1773, correct? I did. That declaration stated that all men are born free and equal and possess the same natural freedom as other men. Your words, yes? Words I supported, yes. And you wrote those words while owning 6 human beings as property? The circumstances are different. That declaration was about British tyranny. It was about tyranny, Sedgwick interrupted. About the injustice of being treated as property instead of free people. About the natural rights that all men possess. You argued those principles justified rebellion against Britain. But those same principles apparently don't justify freedom for the people you own. Can you explain that contradiction? Ashley's jaw tightened. It's not a contradiction. It's a matter of proper legal interpretation. Is taxation without representation slavery, Colonel? It's a form of tyranny. But is it slavery? Is being taxed by Britain the same as being bought and sold as property? The same as having your children sold away from you? The same as being beaten with a heated poker and having no legal recourse? That's not a fair comparison. You're right. It's not fair. Because you fought a revolution over taxation while keeping human beings as property. You wrote beautiful words about freedom while denying that freedom to people in your own household. And now you're asking this court to interpret those words in a way that protects your property rights instead of their human rights. Canfield objected. Judge Whiting sustained it. But the damage was done. The jury had seen Ashley squirm, seen him unable to articulate why the principles he'd used to justify revolution didn't apply to the people he owned. The closing arguments were predictable. Canfield argued property rights, economic stability, the chaos that would result from sudden emancipation. Sedgwick argued that words meant what they said, that freedom was either universal or meaningless, that a constitution declaring all men equal couldn't coexist with slavery. Then the jury retired to deliberate. The wait was excruciating. Mum Bet sat at the plaintiff's table, her expression unreadable. Sedgwick tried to gauge the jury's reactions during trial, tried to calculate odds, but there was no way to predict which way 12 property-owning white men would rule when asked to declare slavery illegal. After 2 hours, the jury returned. Judge Whiting called the court to order. Gentlemen of the jury, have you reached a verdict? The foreman stood. He was a farmer named Samuel Williams, a man who owned 1 enslaved person and stood to lose property if the verdict went against Ashley. We have, Your Honor. How do you find? Williams looked at the paper in his hand, looked at Mum Bet, looked back at the paper. We find for the plaintiffs. The courtroom exploded. The courtroom exploded. Shouts, gasps, arguments breaking out in the gallery. Colonel Ashley sat frozen, his confident expression replaced by something between shock and fury. Canfield was already on his feet, objecting, demanding clarification, insisting this couldn't possibly mean what it sounded like. Judge Whiting pounded his gavel repeatedly, trying to restore order. It took 5 full minutes before the noise level dropped enough for him to speak. The jury finds for the plaintiffs, Judge Whiting repeated, his voice carrying the weight of words that were about to change Massachusetts law permanently. Elizabeth Freeman, formerly known as Bet, and Brom are hereby declared free persons under the Massachusetts Constitution. Colonel Ashley is ordered to pay 30 shillings in damages to each plaintiff for unlawfully holding them as property. 30 shillings, less than 2 pounds. The price of freedom, apparently, was whatever small amount the court could assess without making slavery look as expensive to maintain as it actually was. But the money didn't matter. The precedent did. Mum Bet, Elizabeth Freeman now, officially and legally, stood at the plaintiff's table with the same calm expression she'd maintained throughout the trial. She didn't cry or celebrate or show any of the emotions people expected from someone who'd just won their freedom after 38 years of enslavement. She just nodded once, as if the verdict confirmed something she'd always known. Sedgwick was less composed. His hands shook slightly as he gathered his papers. He'd expected to lose, had prepared himself for establishing precedent for future attempts. Instead, he'd won, and the implications were staggering. If the Constitution declared all men free and equal, and if that declaration had immediate legal effect, then every enslaved person in Massachusetts was legally free right now. Not tomorrow, not after a transition period, right now. The case wouldn't stay secret. Word would spread through the state within days. Every enslaved person would learn that the Constitution supposedly freed them. Every slaveholder would learn that their property had just been declared legally free with 30 shillings in damages as the penalty for unlawful holding. Massachusetts was about to have a crisis. Ashley stormed out of the courtroom without speaking to anyone. His lawyer followed, already planning the appeal that would never come because appealing a freedom case risked establishing the precedent even more firmly. Elizabeth Freeman walked out of the courthouse into afternoon sunshine as a legally free person for the first time in her life. People stared. Some looked horrified. Others looked curious. A few enslaved people in the crowd looked at her with something between hope and terror. Hope that the precedent might apply to them. Terror about what their masters might do to prevent that. Sedgwick caught up to her on the courthouse steps. "Mrs. Freeman," he said, "we need to discuss what happens next. The precedent this establishes." "I know what it establishes," Elizabeth said. "Every slave in Massachusetts just became free under law. Now we see if the law means anything when it costs white people their property. You'll need protection. There will be people who—" "I'll be fine, Mr. Sedgwick. You did what I hired you to do. Now I'll do what I need to do." She walked away before he could respond, leaving Sedgwick on the courthouse steps wondering how an illiterate former slave had just dismissed him like an employee who'd completed his assigned task. Elizabeth Freeman's first act of freedom was practical. She needed work, needed income, needed a place to live that wasn't owned by the Ashleys. Sedgwick offered her a position as a paid housekeeper in his household. The wages were fair, the work no different than what she'd been doing as a slave, except now she could leave if she wanted, could negotiate terms, could save money that belonged to her. She accepted. For the next decade, Elizabeth Freeman worked for the Sedgwick family as a compensated employee. She raised her daughter Catherine as a free person, a daughter who would never know what it meant to be property, who would never have to fear being sold, who would inherit whatever her mother managed to save instead of being inherited herself. The precedent from her case spread exactly as Sedgwick had predicted. Other enslaved people in Massachusetts began suing for freedom using the same constitutional argument. Most won. The ones who didn't win learned that challenging slavery in court was at least possible, which was more than they'd known before. By 1790, the federal census recorded 0 enslaved people in Massachusetts. 0. Slavery hadn't been formally abolished by legislature. No law had been passed specifically freeing anyone. It had simply become legally impossible to hold someone as property when the Constitution declared all men free and equal, and the courts had decided those words meant what they said. Elizabeth Freeman had ended slavery in Massachusetts by refusing to let a scar heal properly. When Sedgwick's wife Catherine died of tuberculosis in 1789, Elizabeth Freeman stepped in to run the household and help raise the Sedgwick children. She became, in practical terms, as important to the family as any blood relative. The children called her Mum Bet out of affection, even though she was no one's property anymore. She was respected in the community, known as an excellent nurse and midwife, called on during emergencies because she remained calm when everyone else panicked. She accumulated money, not a fortune, but enough to provide for her daughter, enough to die with something instead of nothing. And then, sometime in the early 1800s, she disappeared. There's no death certificate for Elizabeth Freeman, no grave marker bearing her name, no documentation of when she died, where she died, or where she was buried. The woman who'd ended slavery in an entire state erased herself from history as thoroughly as if she'd never existed. Her daughter Catherine lived until the 1840s, but never spoke publicly about what happened to her mother. Family records suggest Elizabeth might have moved to New York in her final years, possibly to live with relatives, possibly to escape attention that came with being the woman who'd destroyed slavery through a lawsuit. But no one knows for certain. Susan Sedgwick, Theodore's daughter who'd grown up with Elizabeth Freeman as a second mother, painted her portrait sometime in the 1810s or 1820s. That painting is one of the few surviving images of Elizabeth, and it shows exactly what you'd expect. A woman of dignity and intelligence, dressed simply, with the raised scar on her forearm clearly visible. That scar, preserved in paint, outlasted the woman who'd refused to heal it. The legal case became part of Massachusetts history. Law students studied Brom and Bet v. Ashley as an example of constitutional interpretation, of how plain language in founding documents could be used to challenge established practice. The case was cited in other freedom suits, referenced in debates about abolition, used as evidence that slavery could be ended through legal means rather than violence. But Elizabeth Freeman herself faded from those histories. The case name listed Brom first, as if he'd been the primary plaintiff. The legal analysis focused on Sedgwick's arguments, on constitutional interpretation, on precedent and procedure. The woman who'd walked into a lawyer's office and called him a coward, who'd refused to let evidence of violence heal, who'd stood before a jury and asked which word in "all men are born free and equal" didn't apply to her. That woman became a footnote. Most tellings of the story gave her one paragraph. Some got her name wrong, called her Betty or Betsy instead of Bet. Almost none mentioned that she'd spent 38 years planning this before she had access to a lawyer. Almost none acknowledged that she'd understood constitutional law better than most attorneys despite being unable to read. She became the slave who sued for freedom, not the strategist who'd weaponized her trauma and destroyed an institution. The historical erasure was so complete that by the mid-1800s, most people discussing Massachusetts's abolition of slavery didn't know about Elizabeth Freeman at all. They attributed the change to gradual enlightenment, to natural progress, to the state's progressive values. They didn't know about a woman who'd let a burn scar heal wrong on purpose so she'd have evidence that couldn't be dismissed. Theodore Sedgwick went on to a distinguished political career. He served in Congress, became Speaker of the House, argued cases before the Supreme Court. His obituaries mentioned the Freeman case as a footnote in a career full of accomplishments. None asked what happened to the woman whose case he'd argued. Colonel Ashley died in 1802, wealthy and respected despite having lost the case that ended slavery in Massachusetts. His obituary described him as a patriot, a legal scholar, a man who'd helped draft the Sheffield Declaration. It didn't mention that he'd written words about freedom while owning human beings, or that one of those human beings had used his own words to destroy him. The Ashley Mansion still stands in Sheffield, preserved as a historical site. Tourists can walk through the rooms where Elizabeth Freeman worked as a slave. They can see the kitchen where the fireplace poker incident occurred. They can learn about Colonel Ashley's contributions to Massachusetts independence. Most don't learn about the woman who'd been enslaved there until she sued her way to freedom. The historical marker outside the mansion mentions her briefly, a small plaque noting that an enslaved woman named Elizabeth Freeman had lived there and later sued successfully for freedom. It gives her story 3 sentences, then returns focus to the prominent white family that owned the house. The scar Elizabeth refused to heal outlived her in that painting by Susan Sedgwick. The painting eventually made its way to the Massachusetts Historical Society, where it remains today, one of very few contemporary images of an enslaved person in Massachusetts, one of even fewer showing someone who'd successfully challenged their enslavement. Art historians note the scar when they discuss the painting. They comment on how unusual it was to include such a prominent disfigurement in a portrait, how it must have been important to preserve that detail. Most don't connect the scar to the legal case, don't understand that it wasn't a disfigurement but a weapon, not damage but evidence deliberately maintained. The painting shows Elizabeth Freeman as she was, intelligent, dignified, bearing the mark of violence that she'd refused to let disappear. But the painting can't show what she did, what she understood, what she accomplished. It can't show 38 years of listening to educated men talk about freedom while practicing slavery. Can't show the moment she decided to take their words seriously, even though they didn't. Can't show her walking into Sedgwick's office and demanding he prove whether the Constitution meant what it said. The painting is beautiful. The painting is important. The painting is insufficient. Elizabeth Freeman deserved more than a portrait showing her scar. She deserved to be remembered as the woman who understood that words only mean something when you force people to act on them. Who knew that the gap between declaring all men equal and actually treating them as equal was a gap that had to be closed by action, by lawsuits, by making comfortable people uncomfortable? She deserved to be remembered as the strategist who ended slavery in Massachusetts by refusing to let evidence heal. Instead, she's remembered barely at all. A footnote in legal history. A minor figure in a case that carries someone else's name first. A woman who disappeared so completely after achieving her victory that historians still don't know where she died or where she's buried. The Brom and Bet vs. Ashley verdict happened on August 21st, 1781. Elizabeth Freeman lived free for approximately 2 decades after that, maybe more. She raised her daughter in freedom. She worked for wages. She saved money. She was respected in her community. And then she erased herself so thoroughly that history almost forgot she'd existed. The question that haunts this story isn't how she won. The precedent was clear, the constitutional argument sound, her testimony devastating. The question is why someone who'd achieved something as remarkable as ending slavery in an entire state chose to disappear afterward, chose to be forgotten, chose to leave almost no trace of what she'd accomplished. Maybe she was tired of being exceptional. Maybe she wanted her daughter to grow up without the burden of being the child of the woman who'd destroyed slavery. Maybe she'd fought her battle and wanted peace more than recognition. Or maybe she understood something darker, that America would never really credit a black woman with ending slavery, even in one state, that the story would be told with white saviors and legal precedents and constitutional interpretations, with her as a supporting character in her own liberation. That being remembered meant being rewritten, and being forgotten meant at least being true to herself. We'll never know. She left no writings, no testimony, no explanation. Just a painted portrait showing a scar she'd refused to heal, a legal precedent that freed thousands, and a silence about her final years that remains unbroken more than 2 centuries later. Elizabeth Freeman won her freedom, changed history, and vanished. Whether that vanishing was choice or circumstance, victory or defeat, remains one of the questions she didn't answer. The scar remains visible in the painting. The woman who bore it remains invisible in history.